Hello, sir. Good morning. I memorized the Criminal Justice System or CJS. Philippine Criminal Justice System setting. Law enforcement, also called the police pillar, it occupies the front line of the CJS because they are regarded as the initiator of the system. Prosecution. Take care of evaluating the evidence and formally charge the suspect before the court. Court conducts arraignment and trial. It issues warrant of arrest if the accused is at large and acquits the innocent and adjudicate penalty of the accused I found guilty. Number 4, correction. Responsible for the in- incarceration and rehabilitation of convicted person to prepare for eventual reintegration in community. Help the penitent offender to become law-abiding citizens by accepting the ex-convict re-entry and assist said penitent offender lead a new life as a responsible member of the society, not under or independent among the branches of government. Philippine National Police, organized pursuant to RA 6975 as amended by RA 8551 and further amended by RA 9708. So, police rules and function in the society. Law enforcement, Philippine National Police has the power of enforce law and ordinances relative to the protection of life and property, such as the revised penal code, other specially penal laws, and city and municipal ordinance. Crime prevention, the elimination of the opportunity of the commission of a crime. Police patrol. Patrol has been described as the backbones of the police department. Theoretically, patrol officers are the most valuable people in the organization. Crime detection is the discovery of the police that had been committed. There are traditional ways that occurrence of crime is made known to the police. A. When a victim personally report of crime of the police, when the witness personally reports of the crime to the police, and when the police catch as the offender while in the commission of a crime. Number 5, criminal apprehension. The legal terms of criminal apprehension is arrest. Arrest Rules 113 Section 1 is taking the person into custody in order that he bound to answer of the commission of a offense. Modes of arrest. Arrest by virtue of warrant, arrest without a warrant. An arrest may be the made on any day and at any time of the day or night, even on a Sunday. Warrant of arrest. An order in writing issued in the name of the people of the Philippines signed by a judge and directed to a pace of officer commanding him to take a person into custody in or that the may be bound to answer of the for the commission of the offense. And search warrant, an order in writing issued in the name of the people of the Philippines signed by judge and directed to a peace officer commanding him to search for personal property described therein the bring it before the court, has a validity period of 10 days, can be served only once within its validity period. Personal property to be seized, subject of the offense, stolen or embezzled, and other proceeds fruit of the offense or used or intended to be used as the means of the commission of the offense. Circumstances of warrantless search. Warrantless search in the incidental of lawful arrest under Section 12 Rules 128 Rules of Court in flagrante delicto arrest. And the third basis of evidence, plain view doctrine. Search of a moving vehicle, conceded warrantless search, custody, search, stop and frisk, search and exigent and emergency circumstances. Judicial power is the power to apply laws to contests or disputes concerning legally recognized rights or duties of and between the state and the private person or between individual litigants. In case properly brought before the judicial tribunals, it is vested in one Supreme Court in such lower court as may be established by law. Power of judicial review is the power of Supreme Court to determine whether law passed by Congress and acts of the President are in accordance with the Constitution when the matter is raised. Note, all courts have the judicial, but only the Supreme Court has the power of judicial review. Jurisdiction. It is the authority of the court to hear and try a particular offense and impose the punishment provided by law. Venue refers to the place, location, or sites where the case is to be heard on its merits. Kinds of jurisdiction. Number one, general, when the courts are empowered to decide all disputes which may come before it except those assigned in order courts. Number two, limited, when the court has the authority to hear and determine only a few specified case. Original, when the court can try and hear a case presented for the first time. Number four, appellate, when the court can try a case already heard and decided by a lower court, removed from the latter by appeal. Exclusive, when the court can decide a case which cannot be presented before any other court. Concurrent, when any of two or more courts may take or cognizance of a case. Number 7, criminal, that which exists for the punishment of crime. Civil, that which exists when the subject matter is not of a criminal offense. So, member of the Judicial and Bar Council under the Constitution, Art. Section 8. Chief Justice ex officio Chairman, Secretary of Justice, a representative of the Congress, representative of the Integrated Bar of the Philippines, IBP, a professor of law, a retired member of Supreme Court, a representative of the private sector. So, criminal proceedings. A criminal proceedings consists of 5 main stage or parts. Arraignment, the reading of criminal complaint or information to a defendant by the judge or clerk of court and the delivering to him a copy thereof, including a list of witnesses and him whether he pleads guilty or not guilty a charge. Plea is the response of the accused when asked whether he is guilty or not guilty of the offense charged. It is of two kinds: guilty plea, which must be unconditional, and not guilty. Pre-trial, a conference called by the judge that requires the presence of both prosecution and the accused before the beginning of a trial, mandatory in all criminal cases. Plea bargaining, the process whereby the accused by offender party and prosecution work out the mutual satisfactory disposition of the case subject to a court approval. Trial is the examination before a competent tribunal according to the law of the land, the facts put in issue in a case for the purpose of determining such issue. It is the period for the introduction of evidence by both parties. Order of trials. The prosecution shall present evidence to prove the charge. The accused by present evidence to prove his defense. The prosecution and defense may be present rebuttal and surrebuttal evidence unless the court permits them to present additional evidence. Upon admission of evidence, the case is then submitted for decision unless the court directs them to argue orally or to submit written memorandum. Um, Judgment. the adjudication by court that the accused is guilty or not guilty of the offense charged, and the imposition of the proper penalty and civil liability, defined as the decision or sentence of the given by a court as the result of proceedings instituted therein. A judgment become final PSWP when the period of perfecting an appeal has lapsed, when the sentence is partially or totally satisfied or served, when the accused expressly waives in writing his right to appeal, and when the accused appeal applies for probation. Appeal. The elevation of the argued party of any decision, order, or award of a lower body to a higher body by means of a document which includes the assignment of error, memorandum of argument in support thereof, in relief pray for an appeal must be within 15 days from promulgation of the judgment, the period for perfecting an appeal. Extension of criminal liability, Art 89 RPC, DSA, PPPM. Number 1, death of the convict, service of sentence, amnesty, absolute pardon, prescription of crime, prescription of penalty, marriage of the offended woman in good faith. So, duration of a penalties. Reclusion perpetua, 20 years, 1 day to 40 years. Reclusion temporal, 12 years, 1 day to 20 years. Prison mayor, 6 years, 1 day to 12 years. Prison correctional, 6 months, 1 day to 6 years. Arresto mayor, 30 days to 6 months. And arresto menor, 1 day to 30 days. So, yun. Exclusive clemency. The collective term of absolute pardon, conditional pardon, reprieve, and commutation of sentence. Pardon is a form executive clemency granted by President as a privilege extended to convicts as a discretionary acts of grace. So, two kinds of pardon, absolute pardon and conditional pardon. Absolute pardons refer to the total extinction of a criminal liability of the individual to whom it is granted without any condition whatsoever, and restored to the individual his civil rights and remits the penalty imposed. Conditional pardon refers to the exemption of an individual within certain limits or condition from the punishment that the law inflicts for the offense he has committed, resulting in the partial extinction of criminal liability. So, yun lang po sir ang na-memorize ko, and thank you po and God bless.